here with us to share their expertise and their insights. Former Sergeant for the LAPD, Cheryl Dorsey, and CNN legal analyst Joey Jackson. Cheryl, let me start with you. I just want to get this right to the top, because there will always be people say, well, he grabbed the taser, he resisted, therefore it escalated, and things happen. If you watch the video, and the autopsy says he was shot twice in the back. There was no reason for this to happen, was there?
Absolutely not. Listen, deadly force is to be used as a last resort. That's after you've tried everything. And everything would have included setting up a perimeter, requesting backup, requesting an air unit, a helicopter, describe the suspect and the direction of travel to responding units. Set up a perimeter and contain him within that. Should he slip the perimeter, you already know who he is. You have his driver's license, you have his vehicle. There were so many other things that the officers could have done, but poor tactics always lead to a poor shooting. And now we know, having heard in the voice of the officer, and I believe intent can be formed in a minute. The officer was mad because he took his taser. I know police culture. I was around it. I did it for 20 years, and that was punishment.
That was punishment, you say. And Joey, I just want to read, this is the Atlanta Police Department reasonable force standard. Employees are expressly prohibited from the unnecessary or unreasonable use of force against any person or property. Employees will only use that force which is reasonable and necessary to effect an arrest, prevent an escape, necessarily restrict the movement of a prisoner, defend the officer or another from physical assault, or to accomplish other lawful objectives. I'm not advocating it by any means, but could an attorney for the officer in question here say, it says right here in the standard, necessary to effect an arrest or prevent an escape? He was trying to run away.
Well, you could say that, John, but there's a lot more complexities that factor into this. So let's take you through the analysis. We know about the stop. We certainly have seen the videotapes. We say, and we saw, of course, as you noted, that there was repeated compliance until there was not. I think what they're going to analyze, that as prosecutors, are three separate and independent things. Item number one, in addition, of course, to the very important policy that you just indicated. Item number one, was the officer at the time that the critical moment, right, when the shots were fired, was that officer in immediate fear of death or serious physical injury? What does the videotape show? The turning around of the taser, but then after that, the movement of Rayshard Brooks to leave. Was that, and could that be construed by the officer as immediate fear of death or serious physical injury? Step number two, John, is this. Was the use of force that was engaged in by the officer proportionate to the threat that was posed at the time? And item number three, did the officer act reasonably under those circumstances? Final point. The Supreme Court has weighed in on this and has said officers have to make split-second decisions. I would suspect that the defense will use that, the split-second decision at the moment. What would a reasonable officer in that officer's position have done at the time? And that's where the debate will be. Final point. There are two schools of thought. On the one hand, the prosecutor can charge and allow a jury to make that determination. Why? Because reasonable minds can differ. Shouldn't that be a jury question as to whether the officer acted responsibly, whether he was in immediate fear of death, whether or not the force used was proportionate, or the DA can take it out of a jury's hand and make their own decision? I would suspect that it would, be worthwhile for a jury to make that determination moving forward, and that I think would honor the citizens as it relates to whether or not it was proper and appropriate under these circumstances. That is deadly force.
And Cheryl Dorsey, you just spoke in your first answer about the police culture that you know well, which is why I'm grateful that you're here today. Walk me through that. In the case, in any event, they had Mr. Brooks' name, they had Mr. Brooks' car, and he was running away. But he hadn't committed a violent crime. He was suspected of driving under the influence. He was running away. So what, right? Why can't the police officer say, let him run? We've got his name, we've got his car. He's probably a little drunk, and he's going to run out of gas up the street. I'm going to call for backup. We're going to follow him. We are fine. Yes, he has my taser, but we are fine. Why wouldn't you do that anyway? Why is the training not built there? And then especially in this environment, if you're a police officer, knowing the environment the country is in right now, why not just step back? Let him run.
Listen, the training is there. And ordinarily, a reasonable person would do that. But these two officers were personally invested. And there's a lot of ribbing and teasing that goes on when, number one, a suspect gets away, and let alone a suspect get away with your taser. They would have been teased unmercifully. And I know that. I've seen it. I've witnessed it. And they knew that. And we heard the officer in his own words say, he took my effing taser. He took my effing taser. He was thinking about all of what's going to come next. Maybe days off for not maintaining your property or your equipment properly. All of that was playing through the officer's mind, and he was determined. They were determined he was not going to get away with that taser. They couldn't catch him. Their taser wasn't working. One of the officers fired it, and it was ineffective. They knew the distance between them and him. They know how far a taser will reach. Certainly, they had other opportunities, and because they couldn't catch him, when they finally did fire the fatal shot, the officer who did, you hear him celebrate. He says, "I got him." It was about punishment. It was police culture. It was, you pissed me off and there's a price to pay. Contempt of cop. You made me mad. There's a price to pay, and often it's murder. We've seen it happen over and over again. And in the midst of all that's going on, you would think that would give them pause, but you get tunnel vision as a police officer. And you also have learned through all of the others who've been allowed to kill with impunity that the department will cover you. They'll minimize and mitigate. And that's what's going on right now.
Well, hopefully that part is changing. And as we wait to hear from yet another family that has lost yet another family member at the hands of police, and in this one, when you look at the video, I'm sorry, it's inexcusable. It's not necessary. Joy, I want you to listen here. This is Paul Howard, who's the district attorney of Fulton County. He has to decide whether to charge Officer Rolfe. He also has to decide about the second officer on the scene who did not fire his weapon. Listen to his take.
Under Georgia law, when this second officer did not fire a shot, we are then required to show that he had some actual participation in the final act. So that's one of the things that we are weighing now. And as we've said earlier, we hope to make a decision about that later on this week.
Help me with the issues at play for the second officer here. In the case, and again, there's no direct comparison, but if you look at the case of George Floyd, those other officers, yeah, they say, oh, it was the senior officer who had his knee to the neck. They could have tackled him, they could have pushed him, they could have screamed. They did nothing. What about in this case where one officer fires as a second officer on the scene as part of the pursuit? Is he culpable?
So what happens, John, is that the analysis is wholly different from the issues involving David Chauvin as it relates to the prior case, George Floyd. Here, what you're going to hear the defense argue as to the other officer's mere presence. Yes, the officer was involved with respect to the tussle. Yes, the officer was involved with respect to the chase. However, that officer, separate and apart from his partner, did not fire a shot. That plays in a couple of ways. The first way it plays in is that he didn't think a shot was necessary or appropriate. The second way, though, they'll argue is that he was not in the same vantage point as his other officer. Yet and still, regardless of how we analyze this, I think it comes down to this. There's a feeling that force and lethal force should be a last alternative. It shouldn't rise and fall on charges. It should rise and fall on whether or not something else could have been done. There's a feeling throughout this country, and the marches throughout this country, which I hasten to add, include people of color and not people of color, white people, you know, Spanish, Asian. There's so many, right? People who are marching on the streets. And the issue they're marching for is equal justice. Their issue they're marching for is, why do you have to shoot first and ask questions later? Getting back to the legal issues here, I do think that the partner is in a separate situation, and so you could potentially see, John, charges against the person who fired the shot and no charges as against the partner, you know, in the event the DA decides to move that way.
Joey Jackson, Cheryl Dorsey, very much appreciate your insights and expertise here.